Hi guys, welcome back to I Simplify. In this video, we are going to cover an interesting topic on Indian Contract Act Part 3. Let's start with understanding who are competent to contract. People who are competent to contract include every person who is of the age of majority according to the law to which he is subject, who is of sound mind, and who is not disqualified from contracting by any law to which he is subject. Agreements by minors. Who is a minor? Minor's agreement is void ab initio. Contracts by guardians. Minor may be promisee or beneficiary. No ratification. Necessaries to a minor. No restitution or compensation. Minority as a defense. No estoppel. No specific performance. No insolvency. Minor as a partner. Minor as an agent. Liability for torts, and minor and major. Some important rules regarding minor agreements are: void ab initio. A minor's agreement is void ab initio, that is, the agreement is not valid from the beginning. Estoppel. It is a rule evidence by which a person who has induced another to act on a representation made by him is prevented from denying the truth of his representation. Tort. It is a civil wrong done by one person to another and entitling the victim to claim damages. For example, injury, assault, trespass. Liability for torts. A minor will be liable for a wrongful act only if it is established that the act was independent of contract. In case of wrongs arising out of contract, the minor is not liable. Section 12 defines a person who is of sound mind as follows. A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effects upon his interests. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. For example, a patient who stays in a lunatic asylum may enter contracts at intervals when he is of sound mind. A sane man who is too delirious from fever or too inebriated to understand the terms of a contract or form a rational judgment with respect to its effects on his interests cannot enter a contract until such delirium or drunkenness lasts. The following persons cannot make a contract. A foreigner cannot make a contract. A convict undergoing imprisonment is not capable of entering into a contract. Diplomat or ambassadors are not competent to contract. A person declared insolvent by a court of law is not competent to contract. The next topic is on consent and free consent. Consent, Section 13. When both parties are in agreement upon the same thing in the same sense, they are said to be in consent or be ad idem. When parties are not ad idem, there is no consent. Free consent, Section 14. Consent is said to be free when it is not caused by the following factors: coercion, undue influence, fraud, misrepresentation, or mistake. Coercion, Section 15. Refers to committing or threatening to commit any act forbidden by the Indian Penal Code or the unlawful detaining or threatening to deny any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. Essentials of coercion are: coercion may be used by anybody including a person who is not party to the contract. Further, it may even be directed against a member of the person's household. It involves physical force, fear, and even the use of dangerous substances. It involves obtaining consent by illegally detaining or threatening to detain any property. The act of coercion must be done to cause any person to enter into an agreement. It occurs regardless of whether the Indian Penal Code is in force at the place where. Effects of coercion are: when consent to an agreement is brought about by coercion, the agreement is voidable at the option of the party whose consent was obtained by coercion. A person to whom money has been paid or goods have been delivered with the use of coercion is liable to return it. He may revoke the contract within reasonable time under the Specific Relief Act of 1963. For example, A threatens to shoot B if the latter does not rent his house to A. B agrees to do so. Here, B's consent to the agreement is not free and has been caused by coercion. Therefore, B can void the contract. Next is undue influence. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Essentials of undue influence are: the contract is induced by undue influence and is unfair because one of the parties is in a position to dominate the will of the other. The dominating party uses its position to gain unfair advantage over the other. Burden of proof: when the contract, on the face of it or from the evidence produced, appears to be unreasonable, the burden of providing proof that such a contract was not induced by undue influence lies with the dominating party. Undue influence may exist in relationships such as father and son, husband and wife, doctor and patient, trustee and beneficiary, and solicitor and client. For example, a man weakened by disease or age is induced by X using the latter's undue influence as the former's medical attendant to agree to pay to X an unreasonable amount of money for his service. Thus, X employs undue influence. Effects of undue influence are: when consent to an agreement is obtained by undue influence, the agreement is voidable at the option of the party whose consent was so caused. Any contract obtained using undue influence may be rejected either absolutely or if the party who was entitled to avoid the contract has received any benefit upon such terms and conditions as the court may deem reasonable. Only a party to the contract can revoke the contract. The right to rescind the contract is not given to a third party. Distinction between coercion and undue influence is: in coercion, consent is obtained under the threat of committing an offense, while in undue influence, consent is obtained by a person who is in a position to dominate the other's will. In coercion, consent is obtained by committing or threatening to commit an act forbidden by the Indian Penal Code. In undue influence, consent is obtained by dominating the will of another. Coercion is primarily mainly of physical nature because it involves the use of physical or violent force. Undue influence is of moral nature and involves the use of moral force or mental pressure. Coercion requires the intention of causing any person to enter into an agreement, whereas in undue influence, the influencing party uses its dominant position to obtain an unfair advantage over the other party. Coercion involves a criminal act, while no criminal act is involved in undue influence. Fraud, Section 17, includes any of the following acts committed by a party to a contract, with his connivance or by his agent with intent to deceive another party thereto. It includes the following: offering false suggestions, intentionally concealing an important fact which must be disclosed, making a false promise, any other act used to deceive. Does silence amount to fraud? Keeping silent without any inclination to speak does not amount to fraud. Silence is fraudulent in the following situations: when the circumstances of the case are such that it is the duty of the person keeping silent to speak, or his silence in itself is equivalent to speech. Elements of fraud are: act committed to deceive other party, false statement, concealment of material fact, representation made with the knowledge it is false, act committed to induce the deceived party to act upon it, the other party relies and is deceived, the party suffers loss. If the party does not suffer a loss, not fraud. Consequences of fraud are: recession, damages, restitution, performance of contract, valid contract, truth discovered, contract made in ignorance of fraud. Misrepresentation, Section 18, includes the following. It refers to claiming what is not true, despite the person making the claim might believe it to be true. If there is intention to deceive, it is known as fraud. If there is no intention to deceive, it is termed as misrepresentation. It is any breach of duty which, without intent to deceive, gains an advantage to the person committing it, or anyone claiming under him, by misleading another to his prejudices or to the prejudice of anyone claiming under him. It includes causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing which is the subject matter of the agreement. For example, A tells B that C has a very good horse that can run 20 miles at a stretch. A believes the statement to be true. B purchases the horse from C on the basis of the information received from A. However, B discovers that the horse is able to run only 2 miles. This situation is termed as misrepresentation. Misrepresentation of fact. Consent obtained using misrepresentation of fact allows the party whose consent is so caused to avoid the contract. The contract becomes voidable owing to the misrepresentation of facts. Misrepresentation of law. It does not allow the involved parties to avoid a contract. However, the misrepresentation of a particular right gives the right to the party to avoid the contract. The contract does not become voidable owing to the misrepresentation of law. Effects of misrepresentation. The party whose consent is caused by misrepresentation has the following options. Avoid the contract. Revoke the contract within reasonable time under the Specific Relief Act of 1963. Insist that the contract shall be performed and the party be put in the same position where it would have been if the representation made was true. The party may also claim the damages it is entitled to. Difference between misrepresentation and fraud is: misrepresentation is a false but innocent statement made without the intention to deceive, while fraud is a false statement intentionally made to deceive. In misrepresentation, the person making the statement believes it to be true, while in fraud, the person making the statement is aware of it being false. Misrepresentation makes the contract voidable at the option of the affected party. In case of the fraud, besides making the contract voidable at the option of the affected party, it gives it the right to take an independent tort action. Lastly, in misrepresentation, the contracts cannot be avoided if the party, whose consent was so caused, possessed the means to discover the truth with ordinary diligence. In fraud, the plea cannot be raised, except in the case where silence amounts to fraud. The last type is mistake. Section 20, 21 and 22 define a mistake as when both the parties to an agreement are under a mistake as to be a matter of fact essential to the agreement is void. Essentials of a mistake are: both the parties to the contract must be under a mistake. A bilateral or mutual mistake is an existence fact makes the agreement void. If the mistake is unilateral, the agreement does not become void. The mistake should be one of fact and not of law. The mistake must be essential to the agreement. For example, A agrees to buy a specific horse from B. It turns out that the horse was dead at the time of the negotiation. However, A and B were unaware of the fact. Any wrong opinion regarding the value of a thing cannot be termed a mistake of fact. Effect of mistake of law. A contract is not voidable because it was caused by a mistake as to any law in force in India. Mistake of foreign law has the same effect as the mistake of fact, that is, a foreign law would deem a contract as a mistake of facts does. The mistake may be related to the identity of a person or the subject matter of a contract. Effects of a mistake are: the agreement is void. Any person who has received any advantage under the agreement is liable to restore it or to compensate for it to the person from whom he received it. A person to whom money has been paid or goods have been delivered by mistake must return it. Unilateral mistake. When one of the parties to the contract is under a mistake as to identity, quality or price of the subject matter of the contract, it is a unilateral mistake. According to Section 22, a contract is not voidable merely because it was caused by one of the parties being under a mistake as to a matter of fact. For example, X buys an article thinking it's worth ₹100 when its actual worth is ₹1000. X cannot avoid the contract. Bilateral mistake. According to Section 20, when both parties to a contract are under a mistake as to a matter of fact, the agreement is void. For example, X agrees to buy from Y a certain horse. It turns out that the horse was dead at the time of the bargain, though neither party was aware of the fact. The agreement is void.